Disallowed expenses. That's actually quite an interesting one. There's been one or two people who've commented through that if you have someone who has been coded as deceased, that there's been situations where the reason it happened is because SARS coded you as deceased when they should have coded the taxpayer as insolvent. So just please double check if that applies to your situation. If that is, then you need to change the coding from deceased to insolvent. Okay. Disallowed expenses, right. What can I do to fix this? Now, this is one of those where I wish I had good answers. I really do wish that I had something where I could tell you, here's a magic wand, you can wave it. In terms of the Tax Administration Act, here are your rights, and this is how you fix it. The problem that we have in this particular scenario is twofold. Number one is that if we're looking at 2019, it's 2020, 2021, 2022. There is a very good chance that assessment, that 2019 assessment, not the 2015 one, but the 2019 assessment has actually prescribed at this point. The problem is, remember, in terms of prescription and section 90 to 100 of the Income Tax Act, if a return's prescribed, you can't go and object or appeal or reopen a return. Prescription is like literally like setting that return on fire and going, it is final. Or if you prefer a different analogy, it's like carving it in stone. It's no longer fluid. It is concrete. It is set. It is done. It is finished. And part of the legal philosophy behind why prescription is so strict is because we need a point at which we can't go keep digging up the dead. You need certainty that this is now it, we're done. And if there are issues, then that's it. So the only way that prescription can be overridden is if prior to prescription kicking in, there's an agreement between SARS and the taxpayer in certain conditions, or if you have started a dispute proceeding in terms of Chapter 9, so that's our normal objections, appeals, court processes, prior to prescription, and that issue is still ongoing. And last but not least, is if SARS becomes aware of additional information that there was a misrepresentation or some other misstatement on your tax return. In other words, they have to be able to prove that you did not give all the information that was required in order for SARS to make a valid assessment of your taxes at that point in time. We even have tax law, and this prescription swings both ways in the sense that it doesn't just favor SARS. We've got a case, Medox, where SARS had queried the deductibility of an expense, had kept that particular year open, but there was quite a big assessed loss which had rolled forward into the next couple of years of assessments. Took about 5 years, the case was resolved, and SARS won. But by that stage, all the next years of assessment had actually prescribed. So SARS wanted to go and reopen the 2019, 2020, and so forward years of assessment to go and reduce the assessed loss in each one and roll it forward. And they actually lost at a constitutional court level because SARS went and said, but the 2019 was final. The fact that this number pulled through is irrelevant. Only 2018 was actually kept open. If you wanted this to pull through, you needed to have included 2019 and all further years forward as part of your objection and appeal. Okay. If SARS, one thing I do want to clarify is if SARS has just simply requested additional information. So if we're talking about an audit or if we're talking about a verification, those do not extend prescription. Audits and verifications don't change my prescription timer at all. The only items that will change prescription is objection, appeal, tax board, tax court, and that's it. Okay. So it is one of those where we please um, need to be very careful because honestly, in terms of law in this particular issue, because we've only picked it up now, legally there is actually, we have no recourse under the Tax Administration Act because of prescription. Practically, this is one of those where you go big and plead and go and find a very nice auditor if you can. But we need to accept the fact that legally, we actually have no protection here. What I would suggest that under the Tax Administration Act, your best option at this point is actually possibly a debt compromise route to go to SARS and go and say, guys, this was an additional assessment, all based on disallowed expenses. This person's no longer here. They no longer have any South African assets. Can we just go and hand wave the debt away? It's probably going to be the simplest way to fix it. Your other alternative is that you actually challenge the procedural fairness of that 2019 assessment. Is on what basis did SARS go and raise the additional assessment? Please remember that also Section 95, which allows SARS to raise additional and estimated assessments, has now been amended to go and say that SARS may issue an estimated assessment if requests for supporting information have been ignored by the taxpayer. So previously, you ignoring a request for information didn't, strictly speaking, give SARS the right to just disallow the expenses. They did it anyway, but there were issues with it. So I would is debt compromise is probably going to be the cheapest and simplest way of making the problem go away. Otherwise, arguing about the constitutionality of SARS actually having raised that additional assessment in the first place. Right. Which brings me back to I've got a whole bunch of, I had quite a few comments come through in the chat box of people having issues with SARS suddenly now raising assessments for or asking for information on tax returns which are 5 to 10 to, I think the best or worst, depending on your point of view, that I've seen so far was 15 years from date of assessment to the query. I mean, it related to something to 1998. Now, realistically, in terms of law, you can tell SARS to get knotted because under law, under the Tax Administration Act, when a tax return has prescribed, they can only reopen the assessment into if they have proof of misrepresentation or fraud. In addition, under the Tax Administration Act, you are only required to keep documents 5 years after the assessment was issued. It's for VAT, it's 5 years from when the return was done, but for income tax, it's 5 years from date of assessment. So if we are now talking 2022, and you're being up to date with your taxes, and you've generally always submitted your tax returns as and when. I mean, the most SARS can actually properly go back to is 2016. Because I would have done my 2016 return in January 2017. And then so it's 17, 18, 19, 20, 21, 22. That's actually probably even shifted over a year already because we're halfway down the year. After that, you are not legally required to have kept the information. So if SARS is coming back to you and asking for information on those years, respond in that. Go and say, under I think it's section 23. I stand to be corrected. The document retention criteria of the tax administration act, you're no longer required to have that information. Also, the return is prescribed, so there's actually nothing you can do. Okay. I do know that this has been raised with SARS by the varying RCBs. The fact that they're going back so many years, it almost to me seems like this is one of those where we have um, historic it's almost like they're busy fixing their database again as well, and they are asking taxpayers to submit information rather than actually go and fixing their database themselves. So it definitely seems like there's some cleanup happening in the background, but you actually are not legally compelled to give that information because A, it's prescribed, B, 5-year document retention criteria. Okay. If you have no proof that you submitted the tax return, or that they're saying that no return was submitted, that then becomes a little bit trickier because my 5-year document retention rule only kicks in from the day the assessment was issued. Okay. But that's why it's also actually a good idea to have tax clearances periodically, because then you can go back and say, but hang on, I have a tax clearance here from 2021 showing I was fully up to date with all my taxes, and you're asking for 2005 information. Clearly, I submitted everything. And if I didn't, it's not my problem. Prove to me I was wrong.